Good morning, good afternoon, good evening. It's my great pleasure to open this webinar as part of the celebration of what we are calling Environment Law Week, celebrating Environment Day. Yesterday, we had a webinar on climate change and environmental law. The day before the opening of this week series on the Stockholm Conference, the Stockholm Declaration, and everything else that happened since then, since 1972. And we still have two more events, one on oceans and the other one on biodiversity. It is my great pleasure to introduce the two coordinators, Professor Nicholas Breiner, one of the finest experts on environmental law of, let me call it, the new generation that I have the privilege to know. He is an expert on this particular area that we will be debating today, compliance and enforcement. And also my colleague and dear friend, Alejandra Rabasa, someone that has been focusing her studies and writings and work on compliance and enforcement from a judicial perspective. The panelists are, I would say, the very best in this compliance and enforcement family. We have, first of all, my dear friend Scott Fulton, president of the Environmental Law Institute, the pioneer institution in the United States, but I would say globally, pushing for more attention to compliance and enforcement for at least 30 years, which this is pretty much the time that I've been working with ELI. And in doing so, ELI has focused on the US situation.
You are 1-4.
But also on the global situation, because the compliance and enforcement gap is a global phenomenon. We also have my dear friend and colleague, Justice Damaris Vargas from the Supreme Court of Costa Rica. And Justice Damaris Vargas has been a leading force, not just in Mesoamerica, in Latin America, and globally, vis-a-vis the most crucial issue that we face nowadays, which is the role of judges on compliance and enforcement. She has been writing extensively and speaking extensively on this topic. And finally, we have my colleague, Anne Brosnan, who is a leader in an institution that is also very crucial, I would say central to compliance and enforcement in environmental law, which are the public prosecutors. And when I use the term public prosecutors, I do in both civil law and common law, and recognizing that in some countries they are called district attorneys, they are called U.S. And you correct me, the Americans, U.S. not procurata in China, in the Soviet, in former Soviet Union, and also Russia nowadays. So Anne Brosnan is an environmental public prosecutor, and she is a leader in the European Union network of environmental prosecutors. And those were the first networks to be established. Now we have the Global Judicial Institute on the Environment, but the ones that really began organizing themselves, going beyond their area of work, were the prosecutors. And let me thank Emily Gaskin for helping with everything in organizing this webinar. And I'm sure we are going to have a magnificent discussion on this topic that, I repeat, is absolutely crucial to environmental law. Environmental law is not law in the books. It can't be. And in order to deliver, we need compliance and enforcement. So with that, I give the floor to Professor Nicholas Briner and Alejandra Rabasa.
Thank you very much, Justice Benjamin. Thank you for joining us, and welcome to all of you participants on this panel, and welcome to all of you who are joining from around the world. We're thankful to have you and wish you greetings whatever time of day it is where you're joining us. As Justice Benjamin, the chair of the IUCN World Commission on Environmental Law, noted, this is part of a series of webinars, Environment Week, hosted by the IUCN World Commission on Environmental Law. My name is Nick Briner. I'm the deputy chair of WCEL. And the WCEL, for those of you who are not as familiar with the organization, has over 1,000 members worldwide. It's a global network of environmental law and policy experts from all regions of the world, volunteering their knowledge and services to the International Union for Conservation of Nature. This webinar, as part of this series today, our focus is on developing effective strategies for environmental compliance and enforcement. And so I'm pleased to introduce as well Alejandra Rabasa from the Center of Constitutional Studies at the Supreme Court of Justice of Mexico, who will also be moderating this panel together with me. And before I turn the time over to her for just a moment, in 2019, the UN Environment Program and the Environmental Law Institute released a global report on the environmental rule of law. And in that report, the major finding was that despite a 38-fold increase in environmental laws since 1972, 38 times as many environmental laws over the past 50 years, the failure to fully implement and enforce these laws is one of the greatest challenges to mitigating climate change, reducing pollution, and preventing widespread species and habitat loss. While there are still gaps in many of these laws, despite their proliferation, the substantial growth of environmental laws has been dramatic. So let me turn the time over to Alejandra for just a moment to give an introduction as well on behalf of the Enforcement and Compliance Specialist Group of WCEL.
Muchas gracias, profesor Briner, y muchas gracias al ministro Antonio Benjamin por acompañarnos hoy y dar esta introducción al panel, en el cual realmente es un honor participar con los muy distinguidos y reconocidos expertos, panelistas a los que escucharemos hoy. Yo creo que el tema que nos trae hoy aquí, el pensar en la búsqueda de estrategias efectivas para lograr el cumplimiento y la aplicación de la legislación ambiental, es uno de los temas más críticos en la agenda del desarrollo global, que no puede ya pensarse separado de la atención urgente a la profunda crisis ambiental y climática, de la cual cada vez tenemos alertas más inequívocas de la comunidad científica internacional. Como lo explicó el profesor Nicholas Briner, este panel forma parte del trabajo de la Comisión de Derecho Ambiental Mundial hacia el Día Mundial del Medio Ambiente, que está de 2021, que justamente está dedicado a iniciar la década de la restauración de ecosistemas, muchas alertas como la que hemos escuchado de la plataforma intergubernamental científico-normativa de biodiversidad y servicios de los ecosistemas de las Naciones Unidas, alertan que el tiempo para actuar y revertir los cambios globales a los sistemas de la Tierra que ponen en peligro todas las metas del desarrollo, la reducción de la pobreza, la desigualdad, la libertad para elegir los medios de vida, los derechos de las generaciones futuras. Hay un tiempo muy corto, también un reciente estudio de la Organización de las Naciones Unidas, Hacer las paces con la naturaleza, calcula que tenemos un lapso de 10 años para intentar mitigar la profunda intervención humana en los servicios de soporte de la tierra, alinearnos con las metas del Acuerdo de París para el cambio climático. Y el derecho ambiental se ha identificado en todos estos reportes sobre el estado del medio ambiente en el mundo como una de las palancas transformadoras que pueden utilizarse para revertir el estado actual. Y dentro del derecho ambiental, me parece que el tema del cumplimiento y la aplicación de la legislación ambiental, de todo el sistema de tratados internacionales y leyes nacionales y todo el desarrollo jurisprudencial en el derecho comparado e internacional es la clave para realmente poder dar este cambio que necesitamos para revertir la crisis ambiental y climática actual. Creo que hablar de las estrategias efectivas de cumplimiento y aplicación de la legislación ambiental es un tema que da para muchísimas discusiones, desde la parte voluntaria hasta la parte coactiva, la intervención judicial. En este momento de la pandemia global, también creo que es un tema imprescindible porque pues la crisis económica que está acompañando a la crisis de salud mundial puede tener un retroceso importante en los logros del fortalecimiento de los sistemas de cumplimiento y aplicación de la legislación ambiental, si hay un retroceso donde se piense otra vez que el medio ambiente no es una prioridad. Entonces creo que esta discusión además es muy oportuna en el momento actual porque al mismo tiempo la crisis de la pandemia nos demuestra que ya no es posible pensar en ningún tipo de desarrollo que no ponga en el centro de las preocupaciones a la salud del planeta, la salud ambiental. Entonces, realmente me parece que este panel es oportuno, es importante y espero también que esta oportunidad sirva para impulsar de una manera mucho más decisiva el trabajo del grupo de especialistas de aplicación y cumplimiento de la legislación ambiental en la Comisión de Derecho Ambiental Mundial. Entonces, muchas gracias otra vez a los panelistas que nos acompañan hoy y a todos los que están conectados a este webinar. Nick Reiner, te devuelvo la palabra para presentarlos.
Thank you very much, Alejandra, for those remarks. So again, we're so pleased to have a really great, fantastic panel of distinguished experts who are going to present their views, and we'll have a roundtable format discussion on some of these challenges that Alejandra mentioned with compliance and enforcement in environmental law. So for those of you who are watching, I just want to point you to the Q&A feature at the bottom of your screen. If you have any questions throughout the panel's remarks, I invite you to pose them there. And then with time that we have at the end of this webinar, we will try to address as many of those questions as we can. So if you have any questions, please put them in through the Q&A. So I'd like to introduce just very briefly the three additional speakers that we have here for our panel. First is Justice Damaris Vargas Vázquez of the Supreme Court of Costa Rica, who is joining us today, as well as Scott Fulton, who is the president of the Environmental Law Institute and former judge at the Environmental Appeals Board at the U.S. Environmental Protection Agency. And then also Anne Brosnan, who is the chief prosecutor at the Environment Agency England and is the president of the European Network of Prosecutors for the Environment that Justice Benjamin mentioned a moment ago. So for the three of you, we'd like to hear a little bit from your perspective. What do you see as the most significant challenges for effective compliance and enforcement of environmental laws and policies. Is there a disconnect between the growth of environmental law over the past 50 years and implementation and enforcement? And if so, what do you think explains that disconnect? And in your experience, what strategies can we develop to improve? Entonces, primero pasa la palabra a Magistrada Damaris para responder a estas preguntas.
Muy buenos días a todos y a todas. Es un honor para mí estar nuevamente con ustedes, con Nick, Alejandra, mis amigos, con Scott, Ian. Es realmente un honor esta mesa tan importante. En relación con esta pregunta y aprovechando el corto tiempo que se nos da, la situación que presenta Costa Rica, mi país, es la misma del resto de los países. Excesiva cantidad de legislación y no siempre hay una implementación de esa normativa. La idea es plantear proyectos que integren esa normativa y que le den una visión sistémica. Eso estamos tratando de hacer nosotros en relación con el recurso hídrico. Recientemente nos integramos como país a la OCDE y parte de la revisión que se nos hizo, el monitoreo y seguimiento, es que esta normativa es de muy alto nivel, pero tenemos que responder a ese alto nivel del contenido de la legislación con la implementación, con la aplicación en los casos concretos, especialmente que esté basada o alineada a lo que son los convenios internacionales, que en el caso de Costa Rica son supraconstitucionales por disposición de nuestro máximo tribunal constitucional de manera vinculante, de forma tal que este es una gran oportunidad para amarrar la aplicación de esa legislación que está dispersa de diferentes maneras. Muchas gracias, Nick.
Muy bien, gracias. So next, let me ask Scott Fulton for his remarks.
Good greetings, everyone. Thank you, Nick. It's great to be with you today as we consider this important subject of compliance with and enforcement of environmental law. Especially nice to be led today by dear friends and respected colleagues like Nick and Alejandra, and to be joined by true environmental enforcement champions like Ann Brosnan and Justice Damaris Vargas. I spent much of my career in the enforcement arena as an environmental prosecutor and enforcement program administrator, as a judge adjudicating environmental enforcement cases. So it'll come as no surprise to you that as president of the Environmental Law Institute and the director of the Secretariat for the International Network for Environmental Compliance and Enforcement, or INES, I see effective enforcement as central to the goal of sustainable development, and remain very much committed to building global capacity for this important work. So why is enforcement so fundamentally important? Because at bottom, it's absolutely essential to building environmental rule of law. Recall that formation of rule of law has a number of elements, but a key one is the idea of accountability under the law, the imperative that law be observed or adhered to in practice, that the law rule the actions of those covered by it. This accountability imperative is at its core about compliance, because without compliance, law exists in lifeless form. There is no accountability. There's a gap between the letter of law and what's happening in practice, which we call a rule of law gap. And this gap is a major problem with environmental protection in the world today. The report that Nick and Alejandra have alluded to bears testament to that. So while we have become increasingly adept at building laws, actualizing those laws has remained a major challenge. So why is that? Why is enforcement such a big problem? I'm going to mention 5 factors that come to mind for me, those being problems with resources, with remedies, with resolve, with consistency, and with corruption. These factors are all important in their own right and in their own way, but they are also related one to the other. So let me look at each of these briefly in turn. Resources. Enforcement, at least through the traditional model of surveillance, apprehension, and prosecution, is necessarily expensive. It is inherently governmental in the sense that it's work not easily outsourced to contractors or other parties. It most frequently requires boots on the ground, if you will, or actual application of governmental personnel. So it's expensive. And unfortunately, the public resources for this work are trending down rather than up. And this is one of the considerable problems for the enforcement enterprise. Remedies are also an area of concern. Besides the process of enforcement, what else is expensive? Compliance. Compliance can be quite expensive. Such that if either the law itself or enforcement outcomes do not make it more costly to violate than to comply, then many will choose to violate, taking their chances with the enforcement process. In other words, inadequate remedies can prevent a culture of compliance from ever taking hold in the regulated community. Resolve. It's hard to enforce, and resolve also often wilts under pressure. Important economic interests are often implicated by enforcement cases. Local labor markets can feel threatened by the enforcement process. And indeed, enforcement cuts against the cooperative approach that governments, including regulatory agencies, like to maintain with industry. Enforcement is, in fact, the gutsiest thing that a regulator does, and it often incurs resistance even from other elements of the regulatory agency. Resolve can, of course, also be dampened by insufficient resources and inadequate remedies. This can lead to a sense of futility, which is obviously not the desired mindset for effective enforcement. Consistency over time. Governments have experienced a great deal of difficulty in maintaining consistent commitment to enforcement over the years. And we've seen in recent years wide swings in approach in countries like the United States that have historically been seen as enforcement leaders. So the swing in enforcement intensity from the Obama administration to the Trump administration and now to the Biden administration has been destabilizing to the compliance objective. Increasingly in the United States and elsewhere, this work is seen through a political lens, with politicians characterizing the work as either traditional law enforcement or environmental activism, depending on their political objectives. The last problem I'll mention is corruption. Public integrity is a worry that is, of course, not confined to the environmental space, but it's a confounding presence whenever there's a mismatch between an objective and the resources available to meet that objective, as is typically the case with environmental protection work. Compliance measures, as I've mentioned, cost money, and that tension invites consideration of cheaper workaround strategies like bribery. And underpaid inspectors and enforcers are vulnerable to these temptations. So these are some of the problems in this area. What can we do to confront them and get beyond them to close the rule of law gap? I mentioned 5 problems, so let me mention quickly 5 measures. First, we do need to do more of what we're doing today, sharing experiences and approaches that help us learn from one another, perhaps with particular focus on how to economize law enforcement in the environmental space so that we can do more of it with the limited resources that are available. We need to talk about things like the use of liability standards, like strict liability as an economizing measure, and how to develop manageable burdens of proof for government enforcers. We need to talk about creating self-reporting obligations for polluters that have stiff penalties attached to them for false reporting. So not so many things require government intervention. We need to talk about how to ensure that remedies are powerful enough to incentivize compliance and deter non-compliance. Second, I think we need to see public interest litigation or citizen enforcement as an increasingly important complement to governmental enforcement. This can greatly expand the reach of the enforcement enterprise. Citizen activism can at times feel like a bit of a distraction to government enforcers, I think it's fair to say, but I would suggest that it can be a huge difference maker in the compliance quest. We need to enable it and build into our approach systems that protect citizen enforcers, particularly in response to the rising tide of violence against them, which you'll find cataloged in the Environmental Rule of Law report that Nick and Alejandra have referred to. Third, we need to increasingly deploy emerging technology and communications technology that promise to both dramatically expand our ability to identify environmental problems and their sources, as well as our ability to bring those problems into public view. This should both enable enforcement, but also produce a pressurized setting that induces self-correction of non-compliance without the need for enforcement, and allows for government enforcement to be aimed at more intractable problems. Fourth, I think we need to look at to non-traditional partners to help push compliance. And here I'm really talking about the business community itself. Something important is happening in the private sector. Investors, insurers, lenders, purchasers, supply chain managers are all looking at environmental performance as an indicator of who they want to do business with, who they feel comfortable doing business with. This is a powerful lever because it's about access to capital and access to markets, and there's nothing more powerful than that. So I think enforcers need to get smarter about how to build connectivity with this trend and how to help aim these private sector forces in a direction that makes enforcement by government more targeted and manageable. Finally, I think there's a need for stronger public integrity assurance mechanisms in many countries. And these include both codes of conduct that are aimed at stemming corruption and conflicts of interest, but also independent review mechanisms that investigate allegations of corruption in the environmental space and hold such conduct to account. So those are some thoughts about some problems, some ideas for the solution space. I'll stop there and move it back to our moderators. Thank you.
Thank you very much, Scott, for those points. I think those points are all well taken and can contribute to explaining a lot of the challenges with compliance and enforcement. So let's turn next to Ann Brosnan to hear your comments as well. Your microphone is muted.
Muted. There we go. Can you hear me okay? Yeah, good. Thank you. Well, good afternoon, ladies and gentlemen. Thank you to Professor Breiner, to Justice Antonio Benjamin, and to Alejandra Rabasa for the kind introduction and invitation to this event. I'm very pleased to be in such distinguished company and hopefully amongst some new friends. I agree with this proposition that Nick has propounded, that there is a huge disconnect between environmental law and enforcement. And I think there are many reasons for that, and Scott has touched already on some of those. And there's a great overlap between my thinking and my view on this and his. So I'm going to just touch on 3 of those, if I may, this afternoon. I think the problems can be attributed, amongst other things, to a lack of political will and leadership at a state level and an international level. And Scott described that as resolve, and I think that's the issue that we deal with there. There's been a failure to value sufficiently the environment and nature for itself, an inability to understand the importance of the ecosystem and the wider environment. And thirdly, a lack of resources going into environmental protection. So I'm just going to touch on those 3 points, if I may. The first, the lack of political will and resolve, is really because to date, the environment has not been a key make or break issue for politicians in terms of whether they would be elected or not. There have not been sufficient votes in the environment to make it a key factor for politicians. But I believe that that is changing, and it will change. And that may be because of the pandemic or possibly because of personalities. But I think that change is really important and will make a difference to this compliance gap that we have. I don't think I'm being controversial when I say that any right-thinking environmentalist would welcome the election of President Biden in the US, because there has been a need to push environmental issues up the political agenda, not only the legislative agenda, but the enforcement and compliance agenda. In his first few months in office, President Biden has rejoined the Paris Climate Change Agreement, already held a virtual summit on climate with 40 world leaders, and put the environment onto the agenda of the G7 for 2021. Now, he uses this phrase, the decisive decade, and I think that is absolutely on point. I've just read the communique from the G7 Environment and Climate Change Ministers, and it is amazing in terms of its commitment to environmental protection, but also to putting finance and money and resource behind combating environmental degradation and environmental crime. Pope Francis, in a papal encyclical, set out the papal vision of care for our common home. President Xi Jinping has set out in the 19th conference of the Communist Party in 2017 his vision for a new green is the new gold China, and reaffirmed his commitment to climate change. So we do have some big, powerful world leaders who are now saying the things that we want to hear about the environment. And at grassroots level, I could name lots of people, but Greta Thunberg, many NGOs such as Client Earth, pushing governments to do more. And at an international and state level, you see organisations such as, in my part of the world, in Europe, the European Union really taking a strong line and adopting a real leadership role. This is European Green Week by coincidence. The EU has established its Zero Pollution Action Plan, and both the DG Environment and DG Justice are concentrating on initiatives such as the revision of the Environmental Crime Directive to improve environmental law, but to secure greater on-the-ground compliance. And I think that will address this mismatch that we find. So moving on from leadership, valuing the environment, failing to value the environment. I think that historically the environment was seen as a green amorphous thing that was out there. And I think we now realise the pandemic has brought home to us that we live in synergy with our ecosystem and our environment and how hugely important it is to us. And I think that that lesson will drive environmental compliance and greater concern amongst the wider public about the environment going forward. And I think we now are on at the cusp of a wave that I think will make a difference going forward in terms of environmental protection because of the pandemic and personalities. And finally, I just wanted to touch on resources. Scott has already mentioned resources. Environmental crime is sometimes described as a silent crime. There is no single definition of environmental crime, no common understanding. And that's possibly because it is difficult to attribute a value to impacts on the environment. And that sometimes means that inadequate resources go into dealing with environmental crime. And that happens all along the compliance chain, from inspection and monitoring to the police, to prosecutors, and finally judges. So I quote Abraham Lincoln, laws without enforcement are just good advice. So enforcement is really important to uphold environmental law. And I think that now is the time to look to what the networks are doing. Certainly in Europe, the environmental networks are trying to work together and collaborate more in order that we do more at a joined up level, at a national and an international level. So I'll leave it there and hand back to you, Nick. Thank you very much.
Thank you very much for those, three excellent responses that I think provide such a great overview and introduction to this topic, trying to understand the gaps between environmental laws and environmental enforcement. Let me turn it to Alejandra to ask the next question.
Muchas gracias, Nick. Bueno, muchas gracias a los tres panelistas. Yo creo que esta primera ronda de respuestas realmente cubre de una manera muy interesante e inteligente todo el espectro de temas que están inmersos y que deben resolverse en las discusiones sobre la aplicación y el cumplimiento de la legislación ambiental. Me parece que Scott Fulton ha tocado temas centrales como la parte del desarrollo de estándares de prueba, de pensar más en la responsabilidad estricta en materia ambiental, la parte de citizens enforcement, también me parece crucial, y todo el tema de otros partners para pensar en el cumplimiento de la legislación ambiental más allá del gobierno. Y creo que los remarks de Anne sobre la importancia de lograr también que exista voluntad política, o el daño que hace la falta de voluntad política, son en el momento actual además cuestiones centrales que pueden impulsar o seguir regresionando el tema del cumplimiento y la aplicación de la legislación ambiental. Y creo en este sentido también que el papel de las Cortes, ¿no? Como lo comentaba también la magistrada Vargas, el papel de las Cortes cada vez está tomando un lugar más central en la agenda de las discusiones sobre el desarrollo sostenible. Vemos en las noticias casi todos los días hoy que surge una nueva decisión judicial en Alemania hace poco, en Holanda, el caso Urgenda, en Estados Unidos, litigios climáticos proliferan en las Cortes, en Costa Rica ha habido sentencias emblemáticas sobre el uso de agroquímicos, la aplicación del principio precautorio, indubio pro natura, al igual que en Colombia, en Argentina, en México. Vemos que cada vez más las decisiones judiciales están interpretando los principios rectores del derecho ambiental, pero también enmarcando el derecho ambiental en los principios del derecho internacional, como la buena fe, el deber de no dañar a otros estados, etcétera. Yo quisiera preguntarles a los tres panelistas, con todo este contexto, ¿qué piensan ustedes del papel que estamos viendo de las Cortes y las decisiones judiciales en este contexto tan difícil y regresivo para el cumplimiento y la aplicación de la legislación ambiental? ¿Ustedes piensan que estos ejemplos emblemáticos de decisiones judiciales son outliers todavía, o que estamos pasando a una era más consolidada de jurisprudencia ambiental y que podemos ser optimistas del papel de la adjudicación ambiental para fortalecer y afianzar los sistemas de derecho ambiental. Y Damaris, ministra Damaris, si quisiera empezar con una respuesta o con su presentación para esta ronda de nuestra mesa.
Gracias, Alejandra. En realidad creo que es clave el papel que tiene la gobernanza judicial en la parte ambiental. ¿Por qué es clave? No podemos nosotros depender de las decisiones políticas que se puedan estar planteando, que como mencionaba Anne, tal vez no sea la parte ambiental un tema que genere más votaciones en las elecciones, mientras que en el caso de los poderes judiciales hay una estabilidad que permite tomar ciertas decisiones relevantes. En el caso de nosotros tenemos la experiencia en Costa Rica del posicionamiento que tiene el Tribunal Constitucional con decisiones que son vinculantes, es decir, de aplicación obligatoria, e inclusive está el deber constitucional de la consulta de los proyectos de ley. Esto permite un lineamiento desde el Poder Judicial en esta temática que es trascendental porque busca la integralidad de la normativa interna en relación con los convenios internacionales. Creo que es importante señalar esta brecha que señalaba Scott hace un ratito entre la ley y la aplicación a la que se hace referencia. La aplicación no solamente desde el Poder Judicial, sino también de la ciudadanía. Me parece que la pandemia es un antes o un después desde todo punto de vista en relación con la gobernanza. Nosotros, en el caso de nuestro país, iniciamos la adhesión a la OCDE, a la Organización para la Cooperación y Desarrollo Económico, en 2015, concluimos recientemente. ¿Y por qué hago referencia a esto? Porque el enfoque tiene que ajustarse de acuerdo con post-pandemia. La situación económica de mi país, que creo que no dista de la de muchos países también, hace que muchos de los políticos estén en estos momentos priorizando lo que es la búsqueda de recursos para poder seguir adelante. En el caso de nosotros dependemos sobre todo de lo que es el turismo ecológico, entonces hemos sido muy afectados, pero igualmente tenemos que seguir en la lucha de la parte ambiental. Me parece que es una importante oportunidad que se presenta en este tema de la OCDE, porque son altos estándares internacionales, es rendición de cuentas y monitoreos que van a impactar necesariamente lo que es la eficiencia y el compromiso permanente que tenga el país. Si ya tenemos esta adhesión, eso significa que los siguientes gobiernos tendrán que seguir en esa misma línea de cumplimiento de los estándares que ya se están estableciendo y revisando periódicamente, sumado a lo que es la rendición de cuentas, no solamente rendición internacional, sino también a la ciudadanía costarricense. Y la existencia de este Sistema Nacional de Información Ambiental para las decisiones ambientales que se ha implementado en mi país ha tenido un impacto significativo también a nivel de poder judicial. Recuerdo hace un tiempo que estábamos reunidos en Brasil, varias personas juzgadoras en materia ambiental de diferentes partes del mundo, en el cual evidenciamos una debilidad importante en los poderes judiciales y es el tema de las estadísticas ambientales. Las estadísticas en los poderes judiciales nos ayudan a tomar decisiones de creación de jurisdicciones ambientales especiales. Este tema, ¿por qué lo enfoco? En nuestro país tenemos un tribunal ambiental administrativo, en sede administrativa extraordinaria, agota la vía inclusive, pero ¿qué pasa a nivel judicial? Por las más buenas intenciones que tengamos y un sólido sistema de carrera judicial, es decir, de verificación del nombramiento de los jueces y juezas por idoneidad, de acuerdo con sus competencias, sus conocimientos, sus habilidades, sus destrezas. El detalle es que al no existir una jurisdicción ambiental especializada, la toma de decisiones descansa en jurisdicciones especializadas en derecho administrativo, en derecho penal, en derecho agrario, en derecho laboral, en derecho civil, en todas las especialidades, excepto la parte ambiental, de forma tal que lo ambiental está desperdigado para la toma de decisiones desde los diferentes jueces y jueces de las distintas áreas. Eso significa que es necesario fortalecer sistemas específicos para poder fortalecer esas competencias. ¿Cuáles son los principales retos que enfrenta la justicia agraria en esta situación? Bueno, es fundamental también un compromiso y una interrelación con la toma de decisiones de ciertos sectores, por ejemplo, el sector privado, el sector empresarial. A veces no hay un contacto directo entre el sector empresarial, ciudadanía y sector institucional. Es básico, considero que es indispensable que unamos todos estos esfuerzos, de lo contrario no podemos seguir adelante. Es un ganar-ganar la interrelación que se pueda presentar entre todos. Y hay algunas situaciones en la materia ambiental, se han tomado decisiones extraordinarias en el país. Hemos inclusive tomado parte de las buenas prácticas, lecciones aprendidas de decisiones jurisprudenciales muy importantes en otros países. Sin embargo, cuando llegamos a la práctica, nos encontramos con requerimientos, por ejemplo, de peritajes ambientales. ¿Qué pasa con los peritajes ambientales? Los costos son altísimos. Volvemos al tema económico. ¿Cómo poder solucionar esto? Tenemos que crear sinergias con el sector privado, sinergias con las universidades estatales, sinergias con los diferentes sectores para maximizar el aprovechamiento de los recursos que tenemos. Y si nosotros no buscamos esto desde el Poder Judicial, difícilmente desde otros sectores nos busquen a nosotros, de manera tal que tenemos que tener una visión muy amplia en relación con este enfoque que tenemos que dar, que tiene que ser integral y un compromiso del Estado costarricense o de cualquier Estado que se presente, porque el cambio climático ya no espera. Como señalabas, Alejandra, al inicio, realmente las decisiones tienen que tomarse ya y tienen que implementarse, no solamente que queden en el papel, en convenciones internacionales extraordinarias o en leyes internas también, sino el compromiso y el deber de cubrir esta brecha que se nos está presentando y que estamos evidenciando. Y para eso estamos nosotros como expertas en este tema, para el enfoque respectivo.
Muchas gracias, magistrada Vargas, por estas tan importantes comentarios que ciertamente tocan el centro de las cuestiones a pensar en la especialización judicial y el papel de los jueces crítico en la justicia climática y ambiental. Y ahora quisiera pedirle a Scott Fulton si pudiera darnos sus comentarios respecto a esta pregunta sobre la adjudicación ambiental como estrategia de enforcement y compliance.
Thank you, Alejandra, and very much appreciated Justice Damaris's remarks. I'm an optimist by nature, but I'm also a very big believer in the role of the courts as a critical part of effective governance structure. And I actually believe that there's a basis for hope that the courts will continue to play a key role in the environmental space as they have in so many other areas of social life and social policy. I think in some ways over the past 20 or 30 years, the courts have been the shining star of governance success in many of our systems. And indeed, in the United States, I think the courts have been the most reliable actor within the three branches of government that we operate under over time. And if we look just a little bit outside the environmental space to the role that our courts played in resolving the election irregularity claims in the last presidential election in the United States, and consider the role that the courts have played as generally a check on overreaching by the executive branch. I think we can't say enough about the important contributions of the judiciary. This extends very much into the environmental space as well. I think that there's a certain mainstreaming of judicial thought around the environment that allows for us to see judicial pronouncements in this area, really not as outliers, but rather as a serious attempt to deal with the serious problems that are brought before the courts, and a serious effort to administer justice in a sometimes complex setting. I think that's how they should be seen, and increasingly how they are seen. Judicial pronouncements have been extraordinarily important in the environmental progression in the United States. And I'll just mention as one example of this, what occurred with our Comprehensive Environmental Response, Compensation, and Liability Act, also known as Superfund, well known around the world as the United States' flagship environmental response mechanism for hazardous waste and legacy chemical pollution problems. This story began with the original Superfund Act in 1980, which included which had within it a lot of questions, as many questions as it offered answers. There was a great deal of uncertainty about the core liability principles that would be applied, how causation would work, these kinds of things. The courts stepped into that breach, and through their judicial pronouncements, incrementally added to the body of thought about those mechanisms and measures on issues like causation, strict and joint and several liability. And then the Congress of the United States, in the 1986 amendments to the Superfund law, effectively took those judicial pronouncements and codified them as the law of the land. So if we look at that as an example, we have a situation where the courts fundamentally influenced the liability regime that has helped the United States overcome its legacy environmental pollution problems. There will always be allegations and concerns about judicial activism, as it's sometimes called, this notion that judges through their pronouncements are effectively legislating or regulating or fashioning policy themselves. To my way of thinking, this often turns on the size of the interpreted gap that a judge is trying to fill in order to resolve the matter before her or him, but is also, of course, very much influenced by the perceived strategic value of politicizing the role of the courts. I think what we're seeing is an increasing willingness on the part of domestic judges to look beyond their own borders. This is probably less so in the United States and in other jurisdictions, for comparative law instruction or examples of how other judges have dealt with like problems, and taking that as an important bit of instruction in fashioning domestic judicial solutions. So I think we have this emerging body of international jurisprudence that is domestically centered, but nonetheless deeply influential internationally, That's quite important. We're probably seeing this in its most profound expression in the climate justice space, as judges are looking beyond their borders for examples of how other judges have dealt with climate questions. So all of that to say, I'm both bullish and optimistic about the role of the courts in the environmental space, the important contribution that they have made, and I think in all likelihood will continue to make. Maybe one last point I'll make on this is that there are concerns expressed from time to time, including in the United States, about the politicizing of the judiciary itself. In other words, we've come through a period where a record number of judges were appointed by a very conservative administration, the Trump administration. The federal judges are life tenured positions. So the question is, what does that mean for the administration of justice? If the conservative idea generally looks disfavorably on environmental kinds of causes, does that mean that we'll struggle for justice through the courts and being administered by these judges? Again, I'm going to offer an optimistic thought on this and an optimistic lens, which is that I think for most judges, and of course there are some exceptions, but for most judges, regardless of their political stripes or their political backgrounds, when they become a judge, when they take the oath of office, when they start to practice their craft as jurists, a much bigger idea sets up for them. And that idea is the sacred duty of faithfully following the strictures of the Constitution, of effectuating rule of law. And this, more often than not, will lead judges, regardless of their background, who are serious about the administration of justice, to sound and correct and ultimately helpful decisions for society.
Muchas gracias, Scott Fulton. Después de escucharte, ya me siento otra vez muy optimista yo también. Y además, bueno, el trabajo del Environmental Law Institute para avanzar en el fortalecimiento de capacidades de los jueces y las juezas en el mundo en estos temas, pues es fundamental y otra razón para el optimismo. Muchas gracias. Y Anne Brosnan, ¿podríamos escuchar ahora tus comentarios sobre este tema de la adjudicación?
Yes, of course, Alejandra. Thank you very much. I believe that some landmark judicial decisions will have implications for years to come. And I believe that we live in very interesting times at the moment. Just last week, a decision was made in Europe when Friends of the Earth, the Netherlands, took Shell to court in relation to emissions. And the Dutch court ruled that Shell must cut its CO2 emissions by 45% by 2030. And they said the Paris Agreement applies to companies as well as to governments. And I think that is a huge landmark decision and a great success for the environment. I think we need not only these civil law judgments, but we need some bigger fines and sentences in criminal judgments. In Scott's jurisdiction in the USA, Princess Cruise Lines were fined for dumping oil and polluting material at sea. They were fined $40 million. And that sort of sentence, that sort of massive financial penalty, is the sort of penalty that generates interest with the public and can lead to changes in behavior. And ultimately, this is what we are trying to see changes in behavior and remove criminality. I just want to mention two more cases and a real shout out to Australia for the work that they are doing in terms of environmental protection, particularly between 2017 and 2020. I'll refer to the case of Gloucester Resources and the Minister of Planning in New South Wales. This is, everybody calls it the Rocky Hill case, where a company in New South Wales wanted to open a new open cast mine, and Mr. Justice Preston is the Chief Justice in the Land and Environment Court in New South Wales, who are doing great things for the environment, it has to be said. The court found that the project was not in the public interest after weighing up the costs and benefits, including climate change implications. And it's really good to see climate change implications now coming home and being part of this emerging jurisprudence. So great case there. And I spent some time working in Sydney. I was very lucky. My friends in Sydney keep me up to date with what the court is doing. And so on the 27th of May, just last week, another absolutely landmark decision in the case of Sharma versus the Minister for Environment, where the federal court, a federal court judge, Mr. Justice Bromberg, held that 8 Australian children who had taken proceedings against the minister are owed a duty of care, a new, novel duty of care by the federal Minister for the Environment. And he said the minister has a duty to take reasonable care to prevent injury, to avoid causing personal injury to these children. So I think these sorts of decisions are landmark, and I believe that the courts really are pushing the boundaries in terms of environmental protection. Sadly, these are civil cases. In the criminal courts, we're not seeing, I would suggest, the sorts of sentences that are yet going to change behaviours. The biggest fines in Europe have been £20 million and €20 million in an Irish case, respectively. And when you're prosecuting companies with a multi-billion pound turnover, you need to think what will stop them offending, and messages need to go to shareholders and to directors. So I think we need good sentencing guidelines and gravity factors that identify when cases are serious. But I think we need bold, strong judges who wish to protect the environment. Thank you.
Muchas gracias, Anne, por contarnos estos casos que son inspiradores, como el trabajo siempre de Justice Preston, también un destacado miembro del Instituto Judicial Mundial del Ambiente. Muchas gracias a los tres por esta ronda de respuestas tan importante e interesante sobre el tema de las cortes. En la crisis ambiental y climática, y le paso ahora la palabra a Nick Briner para la siguiente pregunta.
Thank you, Alejandra, and thanks for those excellent responses. It can be tempting in the study of law to just focus on the words in the text, but the lawmaking, as we see, is just one part of the cycle, from public recognition of a problem to a push for addressing that social challenge, adopting new laws, and then continuing on to the fulfillment of those laws through effective compliance and enforcement. And as Dan just mentioned, there isn't one single approach that'll be appropriate in all circumstances, but the compliance and in order to get effective compliance, enforcement really has to be proportional to the size of the problem. So I want to ask you all a question with regard to kind of the present situation as we have been experiencing throughout the world, the COVID-19 pandemic. And in the context of that pandemic over the last year and a half, concerns about economic growth and revitalization seem to be taking more and more of a leading role in global discussions on development. Leaving behind sometimes environmental and climate considerations. I recall in the US, there was an early memo from the Environmental Protection Agency that put essentially on hold a lot of enforcement activities during the first few months of the pandemic in the name of, preserving economic growth. In this kind of scenario, what are the prospects for effective environmental enforcement and compliance? Do you expect that we are going to see an even more deliberate regression on strategies for effective compliance and enforcement? What sort of legal arguments or strategies could be used to face these challenges and avoid regression? And in particular, I'll turn to Justice Damares first and ask you, in addition to those questions, if there are particular circumstances about the environmental compliance and enforcement system in Costa Rica that you would like to comment about, and how those have been functioning, and then what prospects you see in the face of the pandemic that might be challenges.
Gracias, Nick. Yo pienso que la afectación económica ha sido muy significativa en mi país y en el resto de los países. Soy muy optimista también y realista y creo que no todo es negativo en relación con la pandemia. Creo que hay una gran oportunidad en tema de cambio climático, gran oportunidad también en la toma de decisiones. Por ejemplo, el nuevo enfoque post pandemia del teletrabajo viene a generar aspectos muy positivos en el tema ambiental, porque esto, al menos en nuestro país, hay un lineamiento de gobierno para que todas las instituciones, incluyendo Poder Judicial, tengamos al menos el 50% de la población en teletrabajo en sus casas. La medición que se está haciendo, el impacto ambiental de esta decisión ha sido significativa y muy positiva. Muy positiva porque es aumento de producción, el país estaba preparado tecnológicamente para hacer esto, de manera tal que ha sido muy positivo y pienso que no va a tener revés el teletrabajo. Contamos recientemente con una nueva ley de teletrabajo a lo interno del Poder Judicial con un reglamento de teletrabajo, pero ya en estas dos normativas está incorporada la variable ambiental, cuando antes ni siquiera se visibilizaba. El teletrabajo tenía ciertas restricciones a nivel país y a nivel internacional, pero el cambio mundial que ha generado el teletrabajo creo que ha sido significativo para el Poder Judicial y para todas las instituciones. Yo pienso que lejos de regresión, y traigo aquí a colación el principio de no regresión por la progresividad ambiental, que ha sido bastante visibilizado en mi país con muchas resoluciones de los tribunales constitucionales y de las demás salas de casación, algunas iniciativas de la Asamblea Legislativa, del Poder Legislativo, del mismo del Poder Ejecutivo, decretos y de leyes con intenciones de regresión de la protección ambiental han sido frenadas inmediatamente por los tribunales constitucionales especialmente y dejados sin efecto y anuladas esas leyes o esos decretos. Esto significa que el poder que tiene el Poder Judicial es fundamental en la materia ambiental y en la aplicación sobre todo lo que es la normativa. Creo que la pandemia ha incidido en el caso nuestro de que no se haya aprobado aún el acuerdo de Escazú, pese a que fue un acuerdo que se negoció precisamente en Costa Rica, porque posiblemente los políticos, como es normal, están enfocados en proyectos de ley que están requiriendo más recursos para poder seguir adelante, que no necesariamente están con esta visión. Sin embargo, y pese al excelente ejemplo que Anne nos exponía ahora de esa decisión que se tomó aplicando el acuerdo de Escazú, yo pienso que nosotros hemos emitido resoluciones importantes exigiendo la no regresión ambiental y más bien la progresión, aplicando convenciones internacionales ambientales que ya las tenemos en nuestro acervo y que en nuestro caso son supraconstitucionales, es decir, por disposición de jurisprudencia constitucional están por encima de la constitución política. Aquí creo que hay un elemento muy importante y es la independencia judicial, que garanticemos a las personas juzgadoras, a los niveles de mayor jerarquía como magistrados y magistradas, que conserven sus puestos pese a esas decisiones tan importantes que se están dando. Y en el caso nuestro tenemos una sólida carrera judicial que da la garantía de que la persona es designada y no se está revisando periódicamente su nombramiento. Esto es muy significativo para garantizar decisiones sólidas y líneas de pensamiento de progresión ambiental. Y creo que eso ha sido la base más positiva de lo que es la protección de los recursos naturales, y que pese a pandemia y muy por encima de la pandemia sigamos reforzando esta posición. Pero igualmente creo que hay una gran responsabilidad para nosotros como personas juzgadoras, y es que no tenemos que enfocarnos en la visión ambiental exclusivamente, sino también en el impacto que esas decisiones puedan tener en el aspecto social y en el aspecto económico de las comunidades. Hemos tenido ejemplos en que las comunidades reclaman una producción piñera que está generando una afectación a los acuíferos, etcétera. Una decisión judicial pudo haber sido cerrar esa planta de producción. Se nos viene nuevamente la comunidad y nos dice, miren, es que si ustedes la cierran, es nuestro único factor laboral, es el único sitio donde podemos laborar en la zona. Entonces tenemos que tener iniciativa, ponderación en la toma de decisiones y buscar soluciones alternas que protejan el ambiente, pero que además consideren la situación económica y social. Igualmente hemos tenido experiencias con la minería a cielo abierto, una experiencia que tuvo incidencia a nivel internacional inclusive, y la decisión fue el enfoque protección ambiental. En estos momentos estamos enfrentando una situación difícil de la comunidad en que incidió esa decisión, la situación económica y la situación social que está enfrentando, que nos obliga a tomar decisiones por encima de esa otra que se asumió, porque la visión tiene que ser holística, tiene que ser integral entre lo ambiental, lo social y la economía del país, es decir, el desarrollo sostenible, cómo manejar esa ecuación. Y creo que el mejor manejo de esa ecuación está desde las decisiones de las personas juzgadoras, quienes tenemos que ser conscientes que creo que somos la base de todo, porque los políticos son transitorios, los políticos están por sus intereses. Nosotros somos estables, tenemos un sistema carrera judicial, tenemos independencia judicial que nos permite a nosotros tomar la valentía de tomar decisiones significativas en relación con la economía del país y de empresas importantes, sin embargo, de protección ambiental. No obstante eso, mantener la solidez de esa independencia judicial, pero también la solidez de un equilibrio de pensamiento, de un desarrollo sostenible, porque el desarrollo tiene que continuar, pero con protección ambiental. Y creo que esa es la línea que estamos trazando a nivel país con la inserción en la OCDE recientemente. Gracias, Nick.
Muchísimas gracias. Gracias por este ejemplo también, porque verdaderamente no se puede separar la sostenibilidad social con la sostenibilidad ambiental. Paso ahora a Scott para responder a esta pregunta también sobre el principio de no regresión y en el contexto de la pandemia.
I think for starters, it's worth reminding ourselves that before the pandemic, there were certain regressive trends setting up. So for example, if we look at the environmental rule of law report that we've mentioned, we will see in there that there's been an uptick in laws restricting, for example, the presence of foreign non-governmental organizations working on environmental questions and such, as well as foreign funding for domestic non-governmental organizations. I think we must see these as constrictions on the broader enforcement enterprise. We also have already been talking about resource support for enforcement work or environmental protection work as being under enormous pressure, and defunding or downfunding environmental protection agencies and prosecutors and the like is in effect a way of also downscaling enforcement presence and creating a regressive trend line. So we need to understand that those things were already in place before the pandemic came along, As Nick mentioned, the United States is an example of a country that, in response to the pandemic and the great worries about economic impacts associated with the pandemic, a policy was fashioned that basically offered enforcement forbearance in response to environmental compliance problems. That kind of idea is picked up in a number of other countries. It's worth noting that in the United States, that policy ended on August 31st of last year. So that policy is no longer in place. And if people around the world are still citing the US policy as a basis for fashioning like policies, that really cannot serve that purpose any longer. I think that there's reason for believing that just as at times there are challenges in maintaining a progressive agenda on the environment, a regressive agenda also suffers fairly significant durability issues, and the undoing by the Biden administration of a lot of the Trump era policies, I think, are reflective of this. And maybe this just suggests that progressive interests and regressive interests kind of operate at equipoise to some degree in the environmental context because of the complexity of the issues and the linkages to the economy. Equipoise is probably not exactly what we need in order to confront the important challenges of today, but maybe it explains this durability feature to some degree to think of it that way. I mean, ultimately, when we pit economic interests and against environmental interests and the long-term well-being of humanity and the planet, we're offering a false choice. The fact is that we know how to do most of what needs to be done in order to support the human community in an environmentally responsible way. We are not at the frontier on the mechanics of this. We know how to conduct these things in ways that are, if not environmentally benign, have minimized environmental impacts. And when we set up a system that allows or encourages the foregoing of those measures in pursuit of near-term economic achievements, what we're effectively doing is subsidizing near-term activity associated with near-term gains in ways that prejudices the long-term interests of the peoples that we serve. Much better that we engineer into all of our approaches best practices and best technologies that hold everyone to the same standard than we have a patchwork where high-performing countries in one jurisdiction are operating according to one set of standards, but then being outcompeted by companies operating in other jurisdictions whose operations are effectively being subsidized through regressive policies. The international marketplace depends on that kind of leveling out, and our sustainable future likewise depends on that kind of leveling out. One last thought from me, I just wanted to pick up on Justice DeMars's point, excellent point on learning from the pandemic. If we could search for the silver lining in a terrible experience like the pandemic, it's in what we've learned about how to carry on the business of work and how we can do that in both in a more environmentally responsible way, but also in a way that increases our connection to one another and allows us to expand our reach and our use of Zoom and other remote tools like we're doing in this conference has both allowed us to stay home not commit to the emissions and other things associated with the travel experience, but also probably enlarged the size of this gathering. And that, along with how we just think generally about the workplace, where we need to be in order to do work, what we're really trying to accomplish through an office type setting, all of these things, I think we need to be informed by, instructed by, challenged by, and how we design the work of the future. So I appreciated that thought, and this is something that we're trying to think about deeply at the Environmental Law Institute now.
Thank you very much, Scott. And once again, appreciate your optimistic take in trying to look forward on a lot of these issues. So let me ask Anne for your comments as well on this question about environmental law and regression in the face of the pandemic.
Yes, and just a few comments from me, Nick, because a lot of it has already been said. The keywords I think are already out there, which are balance and sustainability. And I think we have to accept that post the COVID pandemic, there is a need to get the world economy moving again, and growth is really, really important. But of course, the restriction is that it can't be at any cost, and protecting the environment and health and safety and other considerations matter and can't be pushed aside just because we need to get growth back on track quickly. We have, during this pandemic, lessened our inspection and monitoring regimes. We've delayed court cases, but I think we can get regulation back on track fairly quickly because all of our standards and our systems and our processes are still there. And so I think we can have growth with regulation, which I think is the way of ensuring that we have balance and sustainability. So I think there is a need for a levelling up agenda to be progressive, but I think there's a need for vigilance also. And in terms of regression, I think there is an important educational need here. We can avoid regression by harnessing public concern. And I think the public and NGOs have a vital part to play in raising public awareness of how to protect the environment and how to promote vigilance. Schools, academia, institutions, organisations all have a part to play in that. And I think vigilance is a really important aspect of environmental protection. So thank you, Nick.
Thank you very much. Alejandra, I'll turn it back to you. And, I believe we'll have time for at least one more question.
Gracias, Nick. Muchas gracias a todas las personas que han hecho preguntas y comentarios para los panelistas. Por el tiempo que nos queda, solo vamos a poder hacer una ronda. Entonces, voy a hacerles, Scott y Damaris, voy a hacer 3 preguntas que se relacionan, que sintetizan algunas de las que hemos recibido de la audiencia, y les pediría que tuviéramos una ronda de 2 minutos máximo cada uno para elegir si quieren dar respuesta a todas o alguna de estas preguntas. Las personas que nos acompañan nos dicen, aún teniendo excelentes leyes ambientales, el cumplimiento de la legislación ambiental, el enforcement y el compliance se quedan cuando no hay voluntad política. ¿Qué podremos hacer? ¿Cómo podemos impulsar? ¿Y cómo ven hacia el futuro que las acciones que pueden hacerse para lograr una mayor voluntad política a nivel global para enfrentar la crisis ambiental y climática? En segundo lugar, ¿qué piensan de los top-down versus bottom-up approaches para promover el cumplimiento de la legislación ambiental en el nivel nacional, donde top-down sería, por ejemplo, la educación ambiental, la conciencia ambiental, una mayor participación del público, y bottom-up sería el enforcement? Y finalmente, ¿qué piensan ustedes del papel que puede jugar el derecho de los derechos humanos para impulsar las estrategias más efectivas de enforcement y compliance de la legislación ambiental? Damaris, podemos empezar contigo 2 minutos para responder alguna de estas cuestiones.
Gracias, Alejandra. Excelentes preguntas todas y todas vinculadas. Yo pienso que podemos y contamos con excelentes leyes, pero la esencia está en la actitud que tengamos para poder cumplirlas y poder aplicarlas a nivel de judicatura al momento de resolver los diferentes casos. Una manera es la sencilla, que es no complicándose mucho, no comprometiéndose. Entonces tenemos que motivarnos, tenemos que tener una actitud de compromiso. ¿Cómo lograr ese compromiso en las personas juzgadoras las que vamos a resolver los casos, o en la ciudadanía en su comportamiento con el tema ambiental? Y ahí mezclo lo que es la educación ambiental y la participación ciudadana. Yo creo que son indispensables que las personas juzgadoras encargadas de la toma de decisiones tengamos cuál es esa visión de la ciudadanía sobre el tema, hacia dónde vamos, hacia dónde quiere ir el país también en la protección ambiental y cuáles son sus requerimientos como ciudadanía, más allá de las decisiones de los políticos. Considero que más leyes no necesitamos, tenemos suficientes leyes, pero es la actitud que tengamos al momento de aplicarla, la iniciativa. Y en esto quiero rescatar con ocasión del derecho, los derechos humanos, que nosotros en algunos foros tenemos un foro de personas juzgadoras de Latinoamérica, donde nos estamos compartiendo muy buenas resoluciones. Sin embargo, no existe, y creo yo que es algo que las organizadoras de este evento podrían considerar, un foro a nivel internacional donde formalmente compartamos esas nuevas iniciativas para que nos ilustren a nosotros en la toma de decisiones, porque los derechos humanos ambientales son lo más importante y lo que tiene que darnos luz al momento de resolver cualquiera de los casos que nosotros enfrentemos. Y el compromiso que tenemos podemos desarrollarlo con educación ambiental, pero el cambio climático cada vez nos va alineando más a esa necesidad. Ya no es algo de nuestros nietos, bisnietos, no, ya es un tema que nosotros estamos viviendo y eso nos exige comprometernos, nos exige la toma de decisiones. Y yo creo, y soy muy positiva, lo estamos logrando. Pienso que lo vamos a lograr, pero es necesario la sinergia, la integración de las buenas prácticas en los diferentes tribunales de todos los países y la creación de estos foros que sean formales y que compartamos esas buenas prácticas, esas iniciativas jurisprudenciales. Gracias,
Muchas
Alejandra.
gracias, querida Damaris, por tus respuestas. Scott, Fulton.
Thank you. Just a few thoughts. Maybe I'll take them in reverse order. The role of human rights to enhance environmental legislation. Obviously, there's this very strong intersection between human rights and environmental protection that needs to be recognized, and human rights law can be an important avenue for environmental gains. The trap to avoid there is to think that by adding human rights to the equation, which is basically adding law content to the equation, that's going to bring us closer to achieving our objectives. We have just been discussing the fact that we are not doing a very good job ensuring compliance with the laws that we have. So adding additional body to the corpus of law may or may not help us achieve our objectives. One thought there. Top down versus bottom up. I think you need both, and if you have both, then maybe that sweet icing in the middle of the cookie is what we call compliance. On this compliance without political will, yeah, this is really a daunting challenge, and I think we need to think outside the box a bit here. I want to pick up on this notion of citizen presence as being part of the equation. Either you try to change the political appetite for this work by creating a pressurized setting within which politicians are working and upping the quotient of their political will. And the way you do that is through transparency and making sure citizens are equipped with information and have opportunities to hold their politicians for account. The other piece of this is looking towards the private sector. I mentioned this before, but it's really important that we somehow tap into what corporations are saying they themselves want to do and what they're trying to do to hold themselves and their business affiliates to account against those expectations, and make that seen as kind of a visible and meaningful part of the enforcement enterprise, the compliance enterprise. There's something there that we haven't quite tapped the way that we might. I'll stop there.
Muchas gracias. Gracias, Scott. Anne?
Yes, and I'm going to only answer one question because we have very short time left. Top down, bottom up, yes, I agree we need both. I agree with the previous speakers in all of their comments. I do think we have enough environmental law, but what we don't have at all levels are clear policies and strategies to make sure that law is implemented, and that requires flexibility and prioritization. And so there's more for the decision makers and the lawmakers to do in terms of making sure we have good effective policies and strategies. And then in terms of credibility, if these don't engage with the public, if the public are not interested, they won't take anyone forward with them, they won't become effective. And so it's really important that there is this groundswell of interest and concern to make sure that appropriate action is taken. And I think that the network I represent and the other European enforcement networks are a really good example of practitioners taking some steps themselves to make sure that we can hold lawmakers to account and try and ensure that these systems work and are more effective. So thank you very much.
Muchas gracias a Anne y pues me ha encantado estar en este panel con ustedes. Muchas gracias y le doy a Nick la palabra ahora al final.
Thank you very much. Thank you to our distinguished guests, to Justice Damaris Vargas Vasquez and to Scott Fulton and Ann Brosnan for being with us and for sharing your thoughts and perspectives. I hope this has left all of you with some good thoughts and some good ideas for the work that each of you individually do around the world. I noted we had over 100 participants for the bulk of the meeting. So thank you to all of you for joining. You know, there are a lot of different competing theories about how to get environmental compliance. And, you know, for some actors that are perhaps solely motivated by economics, it may be a question of increasing the resources for enforcement and increasing the size of economic penalties in order to make sure that compliance is there. For other actors, it may just be a question of providing the right information and technology and capacity and information so that there is a greater awareness and understanding of those environmental laws. But with all these challenges, I would thank you for your comments and look forward to continuing this dialogue in other ways. Grateful to those of you who are watching. We continue to have 2 more webinars in the IUCN WCEL Environment Week. Tomorrow on the United Nations Convention for the Law of the Sea, and then on Friday on biodiversity and the law. So I encourage you to join those as well if you're interested. And thank you. And with that, I bid you goodbye and enjoy the rest of your day.